attorney?
Yes.
Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Mr. Starkey, are you admitting here today that you in fact did batter or injure a law enforcement officer?
That's what I've heard.
And you didn't have consent to do so?
No.
And are you admitting here today that you in fact did throw or expel urine, didn't have consent to do so?
No, I did not.
All right. Do you have any questions for the court or for your attorney before I proceed?
I do not.
Okay. Mr. Keene, did you go over the facts alleged in the criminal complaint with Mr. Starkey?
Yes, Your Honor. Went through all four of them, and more recently, 24 CF 91 and CF 109, along with, we reviewed them on the 4th as well.
All right. And did you go over what the state would have to prove, those elements as they apply to the facts?
Yes, Your Honor.
His constitutional rights and what it means by waiving his rights?
Yes, Your Honor.
And did you go over the strengths and the weaknesses of the cases with Mr. Starkey?
Yes, Your Honor.
And do you believe he's entering his pleas freely and intelligently and voluntarily here today?
Yes, Your Honor.
And do you believe he's entering his pleas competently here today?
Yes, Your Honor.
Do you have any concerns about your client entering his pleas here today?
No, Your Honor.
All right. Mr. Starkey, one last time, do you have any questions before we proceed and before I have you enter pleas today?
No, I do not. I do not have any questions.
Then as to count 1 in 24 CF 91, battery to a law enforcement officer.
Today's courtroom is packed. A young man faces up to 10 years behind bars. Another's DWI put a child's life in danger. Yet another pleads guilty to evading police after a high-speed chase. But instead of harsh prison time, the judge delivers a rare gift: deferred adjudication. For now, because one mistake means the deal is off. In this gripping video, you'll meet Isaac, Dominique, Timothy, and others as they plead guilty to felonies from prostitution to possessing guns as a felon, all in hopes of avoiding a criminal record. But there's a catch. The courtroom may be calm, but the consequences, they're life-changing. Stick around, because just when you think it's all routine, one defendant's drug use threatens to derail everything, and the judge, not holding back. Welcome to real justice. No scripts, no second takes.
And that will remain on the calendar as already previously set. Anything else we need to address here today, Mr. Schmidt?
No.
Mr. Keene?
No, Your Honor.
All right. Then he may be sent back to Polk County so he can face his revocation there and whatever's going to happen there. And then once we determine what's going to happen there, we'll figure out sentencing and how that'll come into play. All right? All right.
That's okay. That's a good time. Understand that. Okay.
We will go on the record in the matters 24 CF 91, 24 CF 109, State of Wisconsin versus Justin Starkey. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Starkey appearing in person in custody with counsel Glenn Keene. We're set today in this matter for the sentencing portion of these cases. Mr. Starkey pled guilty on March 7th, 2025 to 2 felony counts, 1 battery or...
First up, to Shaw Bass, accused of assaulting a peace officer, a 3rd-degree felony that could land her up to 10 years in prison. But before anything moves forward, her attorney insists she'll review the body cam footage. The stakes are too high to gamble on a blind plea, and the judge, surprisingly understanding, she resets the case, giving Daisha the breathing room she needs. It's a reminder: evidence matters, especially when your freedom is on the line.
The counsels, the attorneys, I did not find anything that jumped out to me as being a material error or a fact that needs to be corrected. Mr. Schmidt, did you receive a copy of the PSI?
I did.
Any material facts or corrections to state on the record?
Not a correction per se, but he did get revoked in his Polk case, and they just haven't done the sentencing yet.
All right. And do you know if that matter is currently scheduled for sentencing?
It was scheduled for sentencing yesterday, but Mr. Starkey didn't have an attorney. I didn't see when they pushed it out to.
All right.
Yeah, I can answer that. Scheduled for the 6th, and I work with the public defender because they'd appointed me, but I hadn't got the appointment, so I'll be representing them in that as well.
Okay, excellent. Thank you. And we are in victims' rights compliance, correct?
Yes.
Ms. Bauer, Victims' Rights Coordinator, are we going to have any victim impact statements today?
Yes, Your Honor.
How many?
One.
Just one? Mr. Keen, did you receive a copy of that PSI report?
Yes, Your Honor, and I'm not noting any material errors either.
Okay, and did you go over that report with Mr. Starkey?
Yes, Your Honor.
Did you thoroughly go over it with him?
I had a limited time because we had a phone disconnection, but
Isaac Talley stands to lose it all. He ran from the cops in a vehicle. It's a felony in Texas. But instead of prison, the judge offers a deal. 3 years deferred probation and a $500 fine. Sounds generous, right? Not so fast. One scoop, and the deal is dead. He'll be convicted, and he could be looking at hard time. Isaac nods through the terms, but you can't help but wonder, does he truly understand the weight of what he just signed? Deferred adjudication isn't forgiveness. It's a time bomb with a very short fuse.
If you're going to read something, please make sure that you read it slow, you enunciate your words. The court reporter needs to take everything down accurately, okay?
My name is Jan Lodermeyer.
You can sit if you wish, or you can stand, whatever you prefer.
Last name is Lodermeier. Currently, I'm 911 dispatcher for Gwinnett County. First of all, I want to thank the court for giving me this opportunity. As a corrections and communications deputy for Gwinnett County, it was my job to keep inmates safe, secure, and hopefully healthy. When Justin Starkey was unresponsive in his cell the morning of 3/29/2024, sorry.
And that's okay. Take your time. You can take as much time as you need. We have the rest of the morning scheduled for this case. So if you need to stop, you need a break, you can take that time.
My partner and I at the time went into his cell to make sure he was okay, as he was unresponsive. I bent down to touch his shoulder. He didn't really respond. He started to respond. I thought he was going to sit up. He kicked me in my stomach. I went flying back into a cement wall, and I fell to the cement floor. It's the last thing I ever expected from an inmate.
Then comes Devontae Savoy, just 18 years old. His plea deal hangs by a thread. Why? Drug use. The judge knows something's off, and so does the prosecutor. So, before they sentence him, they order a drug test right then and there. If he's dirty, he's going to ISF, a correctional facility. No questions asked. The courtroom goes silent as his lawyer asks for a moment to speak with him. This isn't just about guilt. It's about whether Devontae is ready to change or if prison is inevitable. At 18, his entire future hinges on a plastic cup.
After 15 months, the doctors tell me I'm as healed as I'm going to be, which means constant pain, constant numbness, and sometimes tingling down my legs. As for Mr. Starkey, my anger is never going to go away. I am not a vindictive person. But honestly, I hate that man for what he has done to me.
And I'm just going to say, I appreciate your emotion. This is not a time to,
I know. That's
To
all I'm going to
attack.
say. That's all I'm going to say about
Okay.
that. Okay. I am no longer a corrections communications officer, deputy. I am now a 911 communications deputy. My life now is to help people that appreciate what 911 communications deputies do, and that is to help the community and save the community when we can.
Thank you. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Sure.
Dominique Richards walks up to the bench calm, collected, but facing a felony. Soliciting prostitution may sound minor to some, but in Texas, it's a state jail felony, and that means jail time unless a deal is struck. The judge offers a path forward, 3 years deferred probation, and a $500 fine. But Dominique needs to walk a straight line. One misstep, and he won't just be convicted. He could be sitting in a jail cell for 2 years. The courtroom is quiet, but the pressure is real. This isn't just about a fine. It's about the fine line between freedom and incarceration.
With a traumatic brain injury that was inflicted on him when he was a baby. However, his criminal history only really began within the past 5 years. The implication there is that the criminal behavior cannot be solely attributed to the traumatic brain injury. He has been placed on probation 4 times and been revoked 4 times. He was on probation when some of the conduct at stake in these cases occurred. He is not a suitable candidate for probation. He gets a disability, that's been confirmed, and at one point on information belief, I believe he was also getting civil payments from the result of how his traumatic brain injury was inflicted. I do not know if he still gets payments for that today. The core behavior of Mr. Starkey in most of these cases is him assaulting and harassing correctional officers. The assaults and harassment show patterns of deliberation and planning and intention. They were not.
Ashley Renfro's case is reset, but the charge? Brutal. Driving while intoxicated. With a child under 15 in the car. It's one of the most serious DWI enhancements in the book. Her attorney pleads for time to gather medical documents. But let's be clear, this isn't just paperwork. This is the kind of charge that triggers automatic jail time if convicted. A child's safety was at stake, and the court knows it. Ashley may be quiet today, but her legal battle is just beginning.
2024. The PSI demonstrates a lot of additional information that the PSI writer acquired contacting other jails that Mr. Starkey was in both before this incident and after. And what the PSI writer discovered was that for over a year before this and sometimes afterwards, Mr. Starkey has been in other county jails, and he has been doing the same behaviors. He has been faking seizures and medical issues to trick COs to try and come in and aid him. The jails have reacted in different ways. Eau Claire seemed to have figured out this and just wouldn't go in and expose their COs. They would see the fake seizures, document it, and then document Mr. Starkey's behaviors afterwards, which show he was clearly faking it. Sometimes his reactions have been violent to them not coming in and checking on him, say attacking the door or the cell. His assaultive behavior has also been directed at inmates in those jails. In 24 CF 248, COs came in to talk to Starkey to stop applying cleaning solution to the mirrors in the cells that they used to see in. They first tried to do it in a safe manner through the intercom. He wouldn't listen and kept doing it. The CO went in to talk with him. The CO's posture in the surveillance camera was very neutral. He was not approaching Starkey. He was just casually standing there talking. And then eventually Starkey got mad, assumed a charging posture, and charged at the deputy. It was completely unprovoked. He wasn't even touching Mr. Starkey or approaching Mr. Starkey when he was attacked. 24 CF 10.
Asterisk next is Timothy Horace Jr., charged with retaliation, a third-degree felony. He accepts a 10-year sentence, but it's probated down to 5 years of community supervision. If he keeps clean, he'll avoid prison, but if not, 10 years awaits. No questions asked. Right behind him is Kendrick Walker, a convicted felon caught with a firearm. That alone is a third-degree felony. He pleads guilty, and the courtroom braces for sentencing. Texas is tough on guns, especially when you're not allowed to have one. For both men, the gavel isn't just
cases, but in the descriptions of these other jails, he's using the empathy of his COs, their desire to help him and to make sure he's not having medical issues to gain access and harm them. He's using positive traits and positive things they're doing against them. It's not just immoral in that sense. It creates a broader public risk to all of the other inmates that COs have to be thinking about and be cautious of other inmates who might be faking just to gain access to harm them. It also shows this more malicious element, because this wasn't a one-off in the JL case of the faking the seizure. We see from the Eau Claire logs, this has been something he's been doing an extremely long period of time. It's a repeated plan that he keeps trying to do and presumably will keep doing in the future. I say that I presume he's going to keep doing it in the future because of how Mr. Starkey talked to the PSI writer.
Asterisk in this courtroom. Justice isn't just black and white. It's filled with gray areas, second chances, hard choices, and brutal consequences. From Isaac's high-speed escape to Dominique's quiet confession, from Deshaw's pending assault, charged to Ashley's DWI with a child. Every decision carries weight, but the judge. She offers a path not always easy, not always forgiving, but fair. If these defendants walk it straight, their records could stay clean. But if they fall, the state won't hesitate. No mercy, no second chance. Thanks for watching this. Real courtroom drama. If you found this video compelling, don't forget to like, subscribe, and share your thoughts in the comments. What would you do if you were the judge? We'll see you in the next one.
The victims in our case, but really the Eau Claire ones, the other county jails where he's done this, the county jail where the CO was coming in with the medical cart, with the medicine that he needed, and he attacked them when they did it. So what am I highlighting? So I've already indicated we have to start first with considering probation. The statute requires that it should be rejected out of hand because of the failures on probation, because two of his recent convictions involved assaults in public in the community, the DC in Burnett, the Eau Claire incident with his mother. The fact he's a danger in the jail to correctional officers itself is also indicative. He can't be treated in the community. That's indicative he needs a higher level of confinement, and that would be the Wisconsin state prison system. They have much better resources. They can have a better documented file and establish easier to use protocols than the county jails he's bouncing to and forth from Polk to Burnett to Eau Claire, and better establish a